Direct Axis extend a very warm welcome to all the esteemed members here, distinguished panelists, and respected guests who joined us
This meeting is being recorded.
here for this important webinar. I acknowledge the presence of all the seniors, Composer, Deepak Mittal ji, Dinesh ji, Hariom ji, Gagan ji, YK Pushan ji, and all the senior names. And friends, before we commence with today's deliberation, I would request everyone to kindly observe a 1 minute silence in the solemn remembrance of the lives lost in the tragic recent attack at Pahalgam and in the remembrance of our martyrs in the Operation Sindhur. Let's invoke peace and pray for the strength and solace of the families affected by this brutal act of violence. A pause for a while. Om Shanti. Thank you, everybody. May peace prevail. CA Pushkal, I request to CA Pushkal Soni ji to kindly temporarily mute all participants so the proceedings may run smoothly. Pushkal ji, please. Friends, with this, let us.
दीपक जी अनम्यूट कर लो अपने आप को।
Pushkal ji, I request you to kindly temporarily mute all the participants, if not yet done. Thank you. And friends, with all that, let's now proceed to the core of the today's webinar. As the secretary of the bar, it gives me immense pride to host this insightful session on the subject of a national and professional significance, the black money, undisclosed foreign income and assets, and imposition of tax act 2015, commonly known as the Black Money Act. As we all know, this brought with it stringent provisions, penalties, and compliance requirements aimed at curbing tax evasion and restoring public trust in the financial integrity of our nation. Dear friends, I'd like to inform everyone that today's webinar is being chaired by President CA IS Khurana ji and Coordinator Study Circle CA Rajesh Jain ji. CA Pushkal Soni ji is there as a co-coordinator, and CA Anshul ji is also taking care of the technical aspects. I feel delighted to name the distinguished speakers for the today's webinar. Advocate Karanjot Singh Khurana, partner at Lakshmi Kumaran and Siddhiraman Attorneys, New Delhi, and Advocate Tanmay Bhatnagar ji, Principal Associate there, who is with us to deliberate this very topic. And we understand that our expert speakers will help demystify the provisions and offer critical insights for practitioners, litigators, and tax professionals. As informed by the speaker, queries may be taken as and when arise or after a reasonable level of the deliberation. And I request speaker sir, when he start the deliberation, kindly he may address the members for the queries way in which he wants to take it. And I request the members to post their queries through the chat box as and when coming to it minds and during query session by raising their hands. Now I request our President Sir, CAIS Khurana ji, to have welcome address to the speaker and to the all present. To the President Sir, please.
Thank you, friends. At the outset, I am very thankful to the dynamic Secretary of the DTBA, Deepak Jain ji, who has concluded all the deliberations in one go. And now I thanks all the participants who have spared the valuable time. The DTBA has endeavored to make program like this, which has the opportunity for the members to gather a lot of knowledge for themselves and also share their valuable knowledge with the other members of the DTBA. So nothing going ahead. I straightway go to our convener, Shri Rajesh Jain ji, to take the control of the proceeding and start this webinar. Rajesh Jain ji.
Thank you, President sir. Thank you, Kranaji. I welcome all the participants to this online webinar on the Black Money Act. For this, we have two learned speakers, Advocate Karanjot Singh Khurana ji and Advocate Tanmay Bhatnagar ji. Basically, the framework of the today's webinar will be like that. These speakers will be starting with what are the main features of the black money, undisclosed foreign income and assets, and imposition of Tax Act 2015, popularly known as Black Money Act. And they will also draw some light on the rules made under the Black Money Act. Then moving forward, they will throw light on final findings and key takeaways from the important case laws concluded under the Black Money Act. And finally, the interplay of Black Money Act between the Prevention of Money Laundering Act, Income Tax Act 1961, the Benami Transactions Prohibition Act, and other economic laws. The queries, as already stated by Deepak ji, can be taken up through during the session, as may be suggested by the learned speakers, or it can be taken up at the end of the session, full deliberation. Now I hand over the proceedings to Secretary Shri Deepak Jain ji for further proceedings.
Thank you, Rajesh ji. Thank you very much. Now I request our executive member, CA Nikhil Kalra ji, to kindly introduce each one of the speaker to all the present. And with all that also, I acknowledge the presence of members who are joining by the time. Nikhil ji, please. Nikhil ji.
Sorry. Good afternoon, everyone. It's a great pleasure to welcome you all to today's session. We are truly honored to have two expert speakers from Lakshmi Kumaran and Sridharan, a leading law firm in India known for its work in tax and economic laws. Let me first introduce Advocate Karanjot Singh. He has been part of the direct tax team at Lakshmi Kumaran and Sridharan since 2015. Karanjot Singh advises clients on various tax matters, including domestic tax, international tax, and transfer pricing. He has worked across many sectors such as banking, oil and gas, IT services, telecom, steel, electricity, and automobiles. He has also done several due diligence projects and handled complex tax issues, especially those involving permanent establishment risks. Apart from advisory work, he regularly appears before different courts and tribunals. He is a frequent speaker at tax seminars and has written many articles in well-known journals. Our second speaker is Advocate Tanmay Bhatnagar, a principal associate in the direct taxes and economic offences team at the same firm. He joined Lakshmi Kumaran and Sridharan in 2018 and is a practicing advocate. Tanmay is an experienced litigator and regularly represents clients before tribunals, high courts, and even the Supreme Court of India. One of his key achievements was being part of the team that won a major civil case for ISKCON Bangalore. He also advises clients from industries like finance, healthcare, and charitable institutions. What makes Tanmay stand out is his ability to combine legal advice in tax with other economic laws, offering clients well-rounded solutions. He also speaks at various events and writes regularly in legal columns and newsletters. We are lucky to have such knowledgeable speaker with us today. Please join me in welcoming Mr. Karanjot Singh and Mr. Tanmay Bhatnagar. We look forward to learning from their experience. Thank you.
Thank you, Nikhil ji. Thank you. Now, without any further delay, I request the speaker, Sir Karan ji and Tanmay ji, to kindly start the deliberation. And Tanmay ji, we are eager to listen to you. Since the time we have listened to you in the earlier days, and we know your ability to deliberate in a very structured manner. Now you are welcome to start your deliberation, sir.
Thank you. Thank you, sir. and good evening to everyone. I think we are truly privileged to have been invited here and to present our views on the black money, undisclosed foreign income and assets, and imposition of Tax Act 2015. Obviously, we'll continue to refer to it as Black Money Act going forward. I think even during my budget seminars, I was discussing with Tanmay as well. One of the biggest takeaway for me individually was the interactions that I had with the members. And I believe that more than I contributing, the questions were so valuable that they added a lot to how I understood the law. And in that spirit, it'll be great that even the session today, it continues to be as interactive as possible. So please feel free to ask questions, put it in the chat box. I have my colleague Snehal and Avar who will be constantly monitoring the questions they've joined as well. They'll be answering some of the questions on the go in the chat box. And obviously towards the end, we'll have a dedicated Q&A also. Again, exchanging news and trying to learn more about this law, the certain provisions of which can be very draconian as far as the taxpayers are concerned. I think with that, we'll just kick off with the black money law and what we have to present there. Now, I think before I just get into what the law is and what it really covers, before I just start as to what the law is and what it really covers, I think I first wanted to take a bit of a background as to why this statute was needed in the first place. See, it's a well-known constitutional aspect that there cannot be two levies on one charging event. So therefore, if there is one occurrence of income, normally there can be only one income tax on it. There can be an additional income tax, right? You can have income tax collected in staggered manner, just like we have income tax and dividend distribution tax, income tax and buyback tax, which are structured to be tax in addition to income tax. But there cannot be two levies on a single charge. That's a fundamental canon principle which we have to remember, because at the heart of it, Black Money Act is nothing but a levy on incomes itself. The entry 82 of the first list to the 7th schedule, it empowers the parliament to create laws to levy taxes on income. Both Income Tax Act 1962 as also the Black Money Act are emanating from the very same entry. And because there cannot be two levies on the same charging event being the income, we will see that both the acts have been kept very exclusive of each other, meaning thereby that if there is an income on which a charge has been created under the Income Tax Act, black money law will not apply and vice versa. So one would then ask a question as to why was this act needed in the first place? In my understanding, bringing this act was more of a political exercise than something which was the need of the hour. In 2006, there was an informant who stole some data from HSBC Geneva. And this informant, after stealing the data, fled to France. Now, by 2008, France was in possession of a lot of bank accounts which were presumably representing undisclosed incomes of residents of various countries. Now, France felt that it was duty bound to share this information with the respective countries because, mind it, France had a double taxation avoidance agreement with India, which also included exchange of information clause. So thereby, France felt that being in possession of the data belonging to the Indian taxpayers, apart from others, they should share the data with India, which they in fact did. And in 2011, it became a household affair that a lot of Indians have their money stashed in Swiss bank accounts, in HSBC accounts outside India, and that the Indian government has got the data which backs up the popular belief, and thereby the Indian government should act upon this data. The current government, which was back then in opposition, they felt that the government should have track down hard on the data that was available for these taxpayers, and that became one of the moot points for them during the election campaign in 2014. So coming into power in 2015, a separate statute was brought into for the foreign assets and foreign income, which ultimately becomes the Black Money Act. Now it is represented, and we'll discuss that many of the provisions under this act are meant to be more onerous as compared to the traditional income tax law, and they are meant to curb or at least act as a deterrent for the Indian taxpayers to stash their money abroad by imposing harsh penalties and prosecution. I think having given that background, just quickly touching upon what I think we all understand what black money is. It's not a term that is defined under the black money law. Typically, it is generally understood to be money that is not reported to the income tax authorities and that exists parallelly to one's declared sources. Now, mind it, black money itself can be generated both from legal as well as illegal activities, right? Now, illegal activities can typically mean activities which are separately punishable under IPC, and legal activities can mean your typical business activities or other, say, windfall activities, which can result in incomes that are otherwise taxable, but still not disclosed, and in that sense, constituting black money. Now, the receipt of income of black money activities could be in India or outside India. For the purpose of black money, we are only concerned with assets and incomes which are outside India. So in other words, where the assets are outside India or where the incomes have their source outside India, those are the target of this Black Money Act, right? Now, the incomes and the assets can be in various forms. So typically in some of the cases that we have seen, say there are some services which are rendered by an Indian party, but a part of the proceeds are parked in a foreign bank account. Now the foreign bank account becomes an undisclosed foreign asset. Similarly, if there are goods which are exported from India and receipts of the part of money are taken in a foreign bank account, presumably if they're not disclosed to Indian authorities and they're not included in your ITR in India, this could become a foreign asset. Similarly, some goods are imported into India, excess payments are made outside India, the expenses are booked here, but part of the proceeds are kept in a foreign bank account. All these are examples where one may be generating foreign income / foreign assets. Yeah, next. So in this backdrop, I think the Black Money Act targets only these transactions wherein people are able to generate the undisclosed foreign incomes and undisclosed foreign assets, and it seeks to create a charge of tax on these alone. Now, under the income tax itself, currently there is a charge as far as these particular foreign assets and foreign incomes are concerned. So when I say that these are applicable to the exclusion of each other, that doesn't mean that there is no overlap between the two statutes. In fact, something that has been subject matter of charge under the income tax is potentially can also be charged under the black money law also, and vice versa. What I mean is that once a valid charge has been created under one statute, the operation of the other one stops. Under the income tax, we know there are provisions under section 68, 69, and so forth and henceforth that which create a special rate of tax of 60% under section 115 BBE. This has existed from assessment year 1819. So then, even despite that, there is a need for black money law. We'll discuss, we'll see how, and which creates a rate of tax of 30% and penalties of 90% on undisclosed foreign incomes and assets. The requirement for this largely arose because under the Income Tax Act, there is a period of limitation of reassessment. At one point, it was 16 years. After 2021, it is now 6 years and further reduced to 5 years from 24. Now, what would happen is, if the period of limitation has lapsed and the officer were to detect foreign incomes after the conclusion of period of limitation, the law was not structured to enable the assessing officer to create a charge of tax on those foreign incomes. Similarly, prior to 21, in many cases, the taxpayers had the option of reaching out to settlement commission to settle their disputes. So even when there was a detection of foreign assets in 2015 to 2021, in many cases, people would go scot-free by reaching out to the settlement commission. On top of it, there are compounding guidelines under the income tax code, whereby even where the taxpayers were being prosecuted for stashing their money outside India, they could go and compound the offenses. Now, many of these problems, they are sought to be settled under the black money law by creating similarly onerous provision when it comes to monetary outflows. And that's where the government felt that in 2015, that a separate code should be created only for foreign assets and foreign income. So in 2015, the then finance minister, Mr. Arun Jaitley, highlighted that black money was curbing black money was an important part of the agenda with which the government was elected, and that the provisions currently in the Income Tax Act, they are seen to be not acting as a deterrent when it comes to stopping the flow of money outside India. And therefore, there were a host of amendments that were made. There were some amendments made to the Benami Transactions Act under the FEMA. And also along with all of this, the Black Money Act was introduced with effect from July 2015. Now, the salient features before we get to the very charging provisions and the way the law is worded, that under the Act, no deduction or allowance of expenditure is allowed as far as the foreign incomes and assets are concerned. The compounding of offenses, settlement commission, all those aspects are completely absent when it comes to black money law. The levy of tax, the charge, that is restricted to 30% only. But the interesting piece is the charge is created not on the value of asset in which at which it was acquired, but it is created on the value as it exists at the time when the asset comes to the notice of the assessing officer. So if I were to acquire a property today, say for 1 crore, and that becomes an undisclosed property, and the assessing officer gets to know about this foreign assets 10 years down the line when the value is 10 crores. So the charge of tax will be 30% of 10 crores in the year in which it comes to the notice of the assessing officer. The penalty is equivalent to 3 times the amount of tax. And this is extremely crucial here. The penalty is not discretionary. It is not up to 3 times. It is equivalent to 3 times. So if an assessing officer in my examples, he observes that I have stashed, I have a foreign asset worth 10 crores, 3 crores becomes my tax, and 9 crores, 3 times the amount of tax, 9 crores becomes my penalty. So the total outflow is more than the value of undisclosed assets. That's 12 crores in my example. The other interesting part is penalty proceedings will run in parallel to the quantum proceedings. In other words, or the appeal proceedings. So in other words, in income tax, we have section 275. What 275 provides is it empowers the assessing officer to levy penalties under section 270A as it exists today once he receives the order of Commissioner Appeals or the ITAT. Meaning thereby that the assessing officer can wait to get the benefit of the order of ITAT. And then once the quantum proceedings have attained finality of facts before ITAT, he can go on to levy penalty under section 270A. Because black money law does not provide for this tolerance, penalty proceedings will continue in parallel when it comes to the black money law, meaning thereby even if you are in appeal, and there are some problems with the order, it is say adversely affecting your rights, etc. Despite that, the officer will be duty bound to continue with the penalty proceedings. Now, in black money law, prosecution can be up to 10 years, not less than 3 years in certain cases, but it can go up to 10 years. This is in contrast to IT Act, where under section 276C for willful attempt to evade taxes, the prosecution is up to 7 years. So therefore, even on the prosecution side, the provisions are worded to be more onerous. Yeah. With this, I think we'll jump on to some of the key definitions and see all these aspects, the way they are worded under the income tax law. Tanmay, you want to take us through the definitions and then each of these aspects?
Yes, I'll do that. Good evening, everyone. So before beginning with the charging provisions or the computation provisions, I think the first thing that we can discuss are some key definitions. Now, in the case of the Black Money Act, the assessee is defined very specifically to mean a person who is a resident under the Income Tax Act under Section 6, or a person who is presently a non-resident or a RNOR, but who was a resident in India either during the previous year in which the undisclosed foreign income or asset is related, or was a resident in the previous year in which an undisclosed asset located outside India was acquired. So therefore, your present status as a resident, non-resident or RNOR is no guarantee of the fact that you may not be assessed under the BMA. Rather, what is critical is whether you are a resident in the year in which that income was earned or that asset was acquired or made. Now, considering that everything is related to undisclosed foreign income or undisclosed foreign asset, therefore, the definitions of those two terms are also very important. So firstly, we'll deal with the definition of undisclosed asset located outside India or an undisclosed foreign asset. So the first condition obviously is that the asset must be located outside India.
Tanmay, please, you may raise your voice.
Sure, sir, I'll do that. Move
Sure.
closer also. Is it better now?
Yeah.
Yes. So, sir, the second condition then comes to the asset being held by that person in his own name or in respect of which he is a beneficial owner. Now, we have dealt with the question of who is a beneficial owner in much detail in later in this presentation. But the overall idea is that that person must have some ownership over that asset which has been acquired and held outside India. The third condition which is important is that even if you have acquired an asset outside India, you are not able to provide any explanation regarding the source of such investment, or the explanation that you are providing is not acceptable to the AO. So that will constitute an undisclosed asset located outside India, which we are terming as UFA for the sake of brevity in this presentation. Now, the next important concept is that of undisclosed foreign income and asset. So that takes into purview the UFA, which we just discussed. It is the total amount of undisclosed income from a source outside India or the value of an UFA located outside India, which is to be computed in the manner provided in sections 4 and 5 of BMA. Now, moving on to the charge of tax itself, that is being created by section 3 of the BMA. Section 3 of the BMA states that it will create a charge of tax on every assessee for every AY beginning from AY 1617, since BMA came into picture on 1st July 2015, in respect of his total undisclosed foreign income and asset of that previous year. And that undisclosed foreign income or asset is to be taxed at the rate of 30%. Now, particularly in the case of undisclosed asset, the question arises, what will be the value at which it will be charged to tax? So as Karan sir was just mentioning, that an undisclosed asset located outside India will be charged at the FMV of that asset in the previous year in which the asset comes to the notice of the AO. So what is not relevant is the year in which the asset was acquired or the asset was made, but rather the only thing which matters is the year in which the AO gets information or it comes to the notice of the AO regarding that asset. The FMV is to be therefore calculated as per the rules which are prescribed under the BMA, which are the Black Money, Undisclosed Foreign Income and Assets, and Imposition of Tax Rules 2015. Now, having discussed the charge, the question now arises, what is the scope of the undisclosed foreign income and undisclosed foreign assets that are to be taxed under the BMA? So the total of the undisclosed income and asset comprises of three elements. The first is the income from a source located outside India, which has not been disclosed in the ITR. Second is income from source located outside India, where there is no return which has been filed. And the third is the FMV of the asset which is located outside India. Now, an important thing to note here is that any income which is included for taxation under the BMA will not be included for taxation under the IT Act. So for this, both the provisions of Section 4 and Section 5 are relevant. So therefore, we'll just move on to Section 5 now. Section 5 now talks about the computation of that income. 5.1 particularly provides that the computation has to, that while computing the value of undisclosed foreign asset and foreign income of any previous year, 3 things are to be seen. Firstly, no deduction or set off or loss will be allowed, even if it was otherwise allowable under the IT Act. Secondly, income which has already been taxed under the IT Act in any year will not be subject to taxation under the BMA. And thirdly, income which is subject to the tax under IT Act will not be again subject to taxation under the BMA. So just before moving on to section 5.2, I will go on to an illustration which will help us understand the computation under 5.1. So in this example, there is a resident who earned 2 different kinds of income from 2 different sources. One was his income from salary, the other was income from gambling activities. Using both these incomes, this person made investment in shares of 2 foreign companies, A and B, neither of which he disclosed in his return of income. And on both, he earned dividend income. However, this individual, he reported the dividend income earned from the foreign company A, the shares of which he acquired from his explained source, that is the salary which he had offered to tax. And he did not disclose the dividend from company B, which he had obtained from his gambling income. So now coming to what will be the total amount which is assessable under the BMA, if we just see with respect to foreign company A, the foreign shares in themselves will not be constituting your undisclosed foreign asset, because the source of that acquiring that asset is well explained and reported also. With respect to the dividend income as well, because the same has been reported in your ITR, there is no question of that being chargeable to tax under the BMA. However, when it comes to foreign company B, which has been acquired from the shares of which have been acquired from gambling, the value of the asset as well as the dividend income, both of which have not been reported in the ITR and regarding which explanation has not been provided, will be charged to tax under the BMA. Therefore, the total sum, including the value of those shares plus the value of the dividend income, will be the amount assessable under the BMA. I'll just go back to section 5.2. Section 5.2 is providing that the amount of deduction under 5.1 in cases of, particularly in cases of immovable property, shall be the amount which bears to the value of the asset as on the first day of the financial year in which it comes to the notice of the AO, the same proportion as the assessable or assessed foreign income bears to the total cost of the asset. So I think it will be again easier for us to understand this provision if we refer to another illustration, which is provided within the provisions of the Act itself. So here let us take an example where a house property has been acquired, located outside India, has been acquired by the assessee in PY 910. Now, out of the investment of 50 lakhs in this property, 20 lakhs has already been assessed to tax in the hands of the assessee in for previous year 910 or earlier years. Now, this undisclosed asset, the house property, comes to the notice of the AO only in year FY 25-26, and the value of that asset in in the year 25-26 is rupees 1 crore. Therefore, the question will arise that what is that proportion of value which is to be taxed under the BMA? Now, if we just see the formula that we have made here is A minus B equal to C, where A is the current value of the asset and B is the proportion of the value which is relating to the previously disclosed investment. So it is not that the entire value of 1 crore will be taxed. You will be getting benefit of the income which has already been reported to and charged to tax under the Income Tax Act. So net an amount of only rupees 60 lakhs will be chargeable to tax in this case. So through these 2 illustrations, we understand how the Black Money Act is looking to operate and what is the scope of the total income which is being brought under its purview. Now, having discussed the charge as well as the computation of the total income, the next step which logically arises is regarding the assessment of that income. Now, an important thing to notice regarding the Black Money Act is that unlike the Income Tax Act, there is no time limit which is prescribed for issuing the notice of the BMA. Rather, the entire act is created in such a manner that it gives a free hand to income tax authorities to bring to tax any undisclosed foreign asset or foreign income in the year in which it comes to their notice. So the period of limitation as such does not exist. What the section 10 says is that the AO can initiate assessment or reassessment proceedings in case he receives any information from either an income tax authority, from any other authority under any other law, or he himself comes to notice regarding that information against the assessee. Thereafter, the AO can conduct an inquiry, and after considering all the evidence which has been brought on record by the assessee, or even in case it has not been brought on record of the assessee, he can finally determine the income tax, the tax liability under the BMA. So there is both a provision for the regular assessment as well as best judgment assessment under section 10. Now, section 11 is dealing with the time limitation period for passing the order, not the initiation, but the passing of the order of assessment. It says that the assessment order must be passed within 2 years from the end of the FY in which the notice under section 10 was issued by the AO. However, here also certain relaxations have been provided to the AO so as to enable him to either effectively carry out this assessment or to seek further information which may assist him in assessment. So as we are all aware that India has entered into various either information exchange treaties or double taxation avoidance agreements with various foreign countries. Under both of these, there is an information exchange clause which is allowing Indian income tax authorities to write to the foreign tax authorities and seek data. So, for example, the earlier example that we were discussing regarding the HSBC data which was leaked from France. Subsequently, after that information was received, Indian tax authorities use that as a base to write to Swiss tax authorities and get that information. So, considering such these provisions in mind, the limitation period has certain exclusions under section 11. The first is that any period during which assessment proceeding is stayed by an order of the court or an injunction of the court, that is to be excluded, which is quite logical. The other thing is that a period starting from the date on which the first reference is made to a foreign tax authority for under the information exchange route from the Indian tax authorities and ending with the date on which the last of that information is received by the PCIT or CIT, or a period of 1 year, whichever is less, that is also an extension allowed to the Indian tax authorities. So effectively, the period becomes 3 years for them to pass an order. Now, an interesting thing that we have dealt with in a recent case here is that there is no transparency regarding the first reference being made to the foreign tax authorities. Considering that as an assessee, we are always at a disadvantage to figure out whether our case is being hit by the period of limitation or not. So in that regard, there is still need of judicial intervention or using routes such as the RTI or inspection in order to ensure that your rights are not getting impacted simply because of a reference being made. Because if a reference is made after the period of limitation has expired, then obviously this benefit cannot be allowed to the AO to pass an order. So this is something which must be practically kept in mind while dealing with these cases. Now, having discussed the assessment, now we come to the penalties and prosecution. Firstly, we will just discuss the overall scheme of the various penalty provisions under the BMA and then the prosecution provisions. So the first is the penalty in respect of undisclosed foreign income or asset, which is discretionary in nature, and the penalty is up to 3 times the amount of tax equal to 3 times the amount of tax which is computed under section 10. So effectively, you are paying 120% tax with respect to your undisclosed foreign asset or income in totality. Then comes the section 42 and 43, which deal with your failure to report. Section 42 deals with penalty for failure to furnish the ITR in respect of the asset located outside India, and 43 deals with a situation where the ITR has been filed, but the sufficient disclosures have not been made in Schedule FA. So as we are all aware, from 2012, Schedule FA was made mandatory, and the scope of that was expanded significantly over the course of time to include not only bank accounts in which you are holding in your name, but in which you are the beneficiary, beneficial owner, or even the signatory. The same thing has happened with respect to trusts, wherein you are a beneficiary. So it is very important for any person while filing their ITR to keep in mind the wide ambit of these of the Schedule FA, as well as the strict penalty which is imposed under Section 42 and 43, which is 10 lakhs per default. So if there is a reporting breach which has happened over a period of time, the penalty can really add up for each instance of such a default. The fourth penalty that we are discussing is the payment penalty for default in payment of tax arrears, which is a penalty equal to the amount of tax arrears. I think that is quite self-explanatory, so I will not get into detail. And then there is a penalty for other defaults, which are defaults such as not adequately responding to the AO during the course of inquiry, stating not cooperating with the AO during assessment. And that is a nominal penalty compared to the other amounts involved here, which will be not less than 50,000, but which may extend up to 2 lakhs. Now, moving on to the prosecution under the BMA. The prosecution provisions under BMA have been made more stringent than the corresponding provisions which were there under the Income Tax Act. The idea being to deter people further by imposing even harsher sentences and fines on people and making sure that this activity is curbed significantly of stashing assets outside India. So the first is prosecution under Section 49 provides for prosecution for failure to furnish ITR. And then 50 talks about failure to furnish information or inaccurate particulars. So these correspond to the penalties under 42 and 43. And the penalty for this offense is a rigorous imprisonment for a period of 6 months to 7 years, along with a fine, which is as per the discretion of the court. Then comes the offense of willful evasion of tax, penalty, or interest. Therefore, a willful default is required on the part of the assessee to be convicted of this provision, and that mens rea element has to be seen. In this case, the imprisonment is provided for a period of 3 years up to 10 years, and again, a fine can also be imposed. Then comes willful evasion of payment of tax under 51(2). Here, in this case, the penalty is slightly lower. It is for rigorous imprisonment for a period of 3 months up to 3 years. And finally, there is prosecution for false statement in verification. In this case also, willful default is required on the part of the assessee or the person who is to be convicted. And there is again a fine and rigorous imprisonment of up to 6 months to 7 years. So as we can see, the minimum penalty also in these cases has been increased, and the outer limit has also been increased compared to the Income Tax Act. Now, I will just hand over the dice to Mr. Karan to discuss the major issues which are arising under the BMA.
Thank you, Tanmay. I think having dealt with the entire framework of the Black Money Act, what we wanted to do is to take forward some of the practical issues that we've seen in the application of black money. And trust me, there are quite a lot that we see. See, the idea here is that by very nature, and Tanmay has been emphasizing each time he's been discussing especially the penal and penalty prosecution provisions, that the whole idea of black money law is to make it more onerous and to make it more harsh for the taxpayers so that it acts as a deterrent. But as most of the tax practitioners here are aware, that in many cases, the powers available to the officer can be used against even the genuine taxpayers. Tanmay talked about the fact that there are some penalties which can be ultimately levied for simple non-disclosure of the foreign asset, even if the sources of assets are otherwise disclosed, right? We looked at the definition of undisclosed foreign assets and we saw that if the source of the income or the source of the asset is not explainable, it becomes an undisclosed foreign assets which can be subject to tax and penalties. But Tanmay explained that in many cases, the fact that the assets are not stated in your ITR can lead to a penalty of 10 lakh. Now, this is a very literal reading of the law, but we know that the devil lies in the detail and that in many cases, it is possible to argue on the basis of judge-made laws, on the basis of constitutional protections, that some of the provisions are to be either read down or they are to be read more liberally than what may meet the eye on the first instance. In this background, we wanted to discuss the aspects on retrospectivity. What is the concept of beneficial owner? What happens when the property was acquired as a non-resident? And then certain exceptions that the courts have made over the period. This is going to be hardcore practical implementations of black money law. And then I think Tanmay will take us through the interplay of black money with the IT Act, FEMA, and then PMLA. Now, first part is regarding the retrospectivity. And this is where it gets very, very interesting. See, we said that the assessment year from where the black money starts is assessment year 16-17. This is obviously with an understanding that this is the assessment year in which the assets come to the notice of the assessing officer and the incomes come to the notice of the assessing officer. In other words, if there were assets that predate the black money law or incomes which predate the black money law, even those can be subject to the charge of Black Money Act in the assessment year in which the assets and the income come to the notice of the assessing officer. How do we read this retrospectivity? It's very well stated in section 72C. 72C, just for my benefit, reads down to say that if an asset is detected by the assessing officer, it will be deemed to have been acquired in the year in which notice under section, notice of assessment, is issued by the AO, even if such asset has been acquired prior to the commencement of Black Money Act and no declaration was made under the one-time disclosure window provided under the Black Money Act. This last part is extremely crucial. When the Black Money Law came, starting 1st July 2015 and ending on 30th September 2015, there was a window which was provided to all the taxpayers to come forward and disclose their foreign assets and foreign income. One would imagine that that period is over and therefore that is not relevant as far as the interpretation of statute is concerned. According to me, that window will continue to be applied against all the taxpayers who had incomes even prior to that. The understanding of CBDT, which is at least also captured in the questions that they've released in 2050, 20 and 29, is that the one-time window was specifically granted to enable the assessees to come forward and come clean once and for all and pay adequate taxes under the Black Money Act. However, if the taxpayers have not availed this opportunity, then the charge of the tax can still be applied retrospectively, and even the penalties and prosecution can be applied retrospectively. That's what CBDT wants to say. However, the application of this retrospective application of BMA, this has been a subject matter of dispute. And I must say there are judgments on both sides. I think we'll just discuss these judgments before we exchange thoughts on how we should read this particular provision. So take example of this judgment of ITAT Mumbai. This Rashesh Manhar Bansali, where assessee had an undisclosed foreign bank account that was acceptedly open prior to the enactment of the Black Money Act. The assessee contended that the Black Money Act is applicable only in relation to the assets that the assessee continues to hold at the time of the enactment of the Act. The ITAT held, interestingly so, that the assessment can be made under the Black Money Law, even if the assessee had disposed of the assets prior to the Black Money Act coming into the effect. The tribunal even cited a Supreme Court judgment, Gautam Khaitan, to say that the relevant point of taxation under the Black Money Act is the point of time when the assets come to the notice of the AO. The existence of the asset at the time when they come to the notice is irrelevant, at least as per ITAT. Right? I must point out, we are here dealing with the charge of tax. It is very well understood and a fundamental principle that legislature consciously can create retrospective levies of tax. intentionally, if the legislature wants to, for a statute to be retrospective, they can do it as far as charge of tax are concerned. So what the ITAT is saying in that sense is not very it's not very unfounded, and in that sense not very alarming, because they're simply applying the charge of tax retrospective. It's a separate matter of debate as to whether the interpretation is correct or not. Under Section 3 of the Black Money Act, the charge is created in respect of undisclosed foreign incomes and undisclosed foreign assets. Now, the assessee is arguing that what the assessing officer is charging is no longer an asset itself. The matter has been appealed, and this particular point, I think this will be decided by the courts as we move along. But what I'm saying is, as a concept, to apply the charge retrospectively is not alarming, and it is possible that the higher forums may end up echoing the view as far as this charge of tax is concerned. Now let's look at the retrospectivity when it comes to penalty proceedings. Now this is very important. We must remember that as far as Article 21 is concerned, it is already a constitutional protection granted to all people that no person shall be convicted of any offense except for violation of a law which is in force at the time of the commissioning of the act. And on top of it, the penalty cannot be greater than what it would have been inflicted under the law that was applicable when the offense was commissioned. Now, in this background, let's discuss as to whether the penalties can be retrospective under Black Money Act or not. I think I've already read Section 72. As far as the Parliament is concerned, they want to apply the act retrospectively. I think that goes without saying. Where the dispute will lie is in the fact that a window was provided to the taxpayer. Now, say for example, Karan had earned foreign incomes in 2015 prior to the commencement of this act, say in Jan of 2015. Karan is able to prove that these incomes were earned at that time. The period of limitation of assessment under IT Act is over. You cannot go back and reassess these incomes. The assessing officer comes and tries to create a charge of tax today in 25 because he's got to know about the existence of these foreign incomes in 25. Karan will go on to tell the officer that my act was the offense that you are alleging against me to conceal the foreign incomes. This particular act was commissioned at a time when the black money law was not in existence. Therefore, I have a constitutional protection under Article 20. And therefore, you cannot levy penalties on me. The argument which is coming from the officer, and interestingly so, they are saying we are not levying penalty for concealing incomes in Jan 2015. We are levying penalties for not disclosing incomes in the period of June 2015 to September 2015 when we gave you the window. The window was not applicable to incomes and assets which were in existence during this time. These were applicable to all foreign incomes and assets. Therefore, by not disclosing the foreign income that you earned in Jan 15 during the window of June 15 to September 15, Karan has undisclosed foreign incomes, and the offense is being alleged at a time when the black money law was in force. And therefore, for that reason, the officer is trying to levy penalty on me, which is equivalent to 3 times the amount he would have assessed under Section 3. So in this particular case, like take this example of Akhil Abbas. The assessee had a foreign insurance policy which had lapsed prior to the enactment of Black Money Act, and for which a penalty was imposed under Section 43 for non-disclosure in the ITR. The ITAT has held that penalty under Section 43 cannot be imposed if the assessee is not if the assessee is not holding the asset at the time of enactment and the enforcement of at the time of enactment of the statute. Now, the interesting thing here is this: we are talking about the penalty under 43 for non-disclosure of the asset in the ITR. We are not talking about the penalty for not disclosing the for not offering the undisclosed foreign incomes during the charging window, the penalty which is 3 times. 43 penalty is only 10 lakh rupees. It is possible for an officer to come and say that 43, 44 we are ready to concede, but 42, which is the more onerous penalty of 3 times of the quantum of tax assessed under black money law, that is applicable. Now, all these matters for 42, they are still pending before higher courts, and we are yet to see the final word on this. But I must say, this will be a very interesting aspect, because very similar issues are being debated under money laundering also, where the similar issues are coming, that if someone is holding proceeds of crime for a scheduled offense prior to an offense being scheduled under PMLA, as to whether they could be subject to PMLA or not. And there some judicial forums have in fact stated that if after the offense is scheduled, you still continue to hold proceeds of crime because it's a continuing offense, therefore you can be subjected to penalty. Will not be surprised if the higher forums end up taking something similar. And that's where I said that small 3-month window is going to haunt many of the taxpayers when they continue to litigate their matters as far as Black Money Act is concerned. Now, I think another case that we wanted to discuss is this Dhanashri Ravindra Pandit, whereby prosecution was initiated under Section 50 of Black Money Act for non-disclosure of foreign shares in the ITR. Now, these shares had been disposed of prior to the BMA's enactment. Now, High Court, interestingly, the Karnataka High Court has taken recourse to Article 20 to give protection to the taxpayers. And in fact, they've gone on to say that 72C is violative of Article 20. The appeal against this is pending before Supreme Court, and the very same arguments that I've dictated just right now, those are being argued by the revenue before Supreme Court also. With this, I think we wanted to jump to the issue of beneficial ownership under black money law. Now, why the concept of beneficial owner is important? Because the definition of undisclosed foreign asset benchmarks the asset held by the assessee or of which he is a beneficial owner. Now, that's where the concept of beneficial owner becomes extremely crucial. Now, one part that I wanted to explain is that beneficial ownership is defined under the Income Tax Act in Section 139 in the context of foreign assets only. Separately, black money law says that any terms not defined in the IT Act, the reference of those terms can be taken from the black money law. Now, in this particular background, let's see what the courts have stated when it comes to concept of beneficial ownership. In the case of Jitendra Mehra, ITAT Delhi has said that when it comes to the concept of beneficial ownership, the meaning under Section 139 can be imported for the purpose of Black Money Act. And therefore, when Section 139 provides that beneficial owner means the person who has paid consideration for acquiring the assets or for taking control of the asset, that meaning can be imported, and a person, once it is proven, was the source of the consideration pursuant to which a foreign asset came into existence, then that person can be penalized and the charge of tax can be created against him. Interestingly, in case of Rashesh Manhar Bansali, the assessee tried to use this very argument in its favor. In this particular case, the assessee was was the beneficial owner in a very layman's sense, but the consideration was paid at the behest of the assessee by some other person. So the assessee tried to argue that, hey, consideration has been paid by Mr. A. The allegation is the consideration is paid at my behest. Therefore, I am not the beneficial owner. It is the person who paid the consideration. Now, one fundamental principle which is generally there in laws, which was also applied here by ITAT, is they said the references by legislation are always contextual. Therefore, we will import the meaning when the context warrants us to import the meaning. Now, they said in the context in which the beneficial owner is used, that is meant to say the person who has some sense of control over the asset. Just by saying that the consideration was not directly paid by the SSC, importing meaning from income tax will be very violative of the very intent of the black money law. And therefore, what was provided was that in this particular case, the meaning given in section 139 cannot be imported. And in fact, the SSC is a beneficial owner. Similarly, in a recent case in ITAT Mumbai, it was held that merely because the SSC was named as a joint owner for administrative convenience, that would not mean that the SSC becomes a beneficial owner for the purpose of Black Money Act. Now, this aspect is extremely crucial, and there are other similarly placed judicial pronouncements. See, increasingly what we have seen is that in many cases, many Indian residents, they have certain foreign assets to their name just for the purpose of facilitation or for the purpose of certain legal compliances, etc. We have come across cases where, say, for example, an Indian employee was made a signatory to the foreign bank account of the Indian company. He's only an employee, not otherwise controlling the foreign bank account, etc. Only a signatory for check purposes and all that. The department says, well, because you have a financial interest, you should have disclosed the bank account. We have similarly seen cases where people, in order to help their family members, they become trustees of certain foreign trust. The department comes and says, well, the properties of the trust are in the name of the trustee, and therefore you are the legal owner of these assets. So in many genuine cases, the department is using the very onerous provisions which form the definition of undisclosed foreign asset to say that the mere fact that the assets are in the name of the taxpayer is sufficient to say that the SSC is in fact the beneficial owner. Now, obviously, as far as the beneficial ownership is concerned, that can be very easily demonstrated, because that means that you should be in a position to enjoy the benefits of the asset. So merely because there is some legal name that bears against the asset, that alone cannot be sufficient. But what is more interesting is undisclosed foreign asset benchmarks beneficial ownership and holding of asset in the name of the SSC. It says held in the name of the SSC. The officer would say that even if you say it is not in your beneficial ownership, the mere fact that the asset is held in your name is sufficient for us to go against you. If we look at the definitions in Blacklaw's dictionary and other places, the term held means that you should be in some form of legal possession of the asset, meaning that you should have some legal control over it. In a case where your name is only added for facilitation, etc., and you're able to demonstrate that you don't have any legal ownership of the asset, you should be able to defend that neither is the asset held by you, nor it is beneficially owned by you. Obviously, the burden of proof here will lie on the SSC, but if it is a bona fide case, I'm sure that the taxpayer should be able to prove that they should not be subjected to the onerous provisions of black money law, but in fact, the person who is actually the beneficial owner or the legal owner, those should be subjected to the provisions of Black Money Act. I think we also wanted to touch upon this particular aspect of acquisition of property as a non-resident. We discussed that the definition of assessee under the Black Money Act, it means a person who is resident as far as the at the time when the income is earned by it or the asset is acquired by it. Now, it also includes a person who is a non-resident or a resident but not ordinary resident, who was resident in the year in which the undisclosed foreign income and asset related to, or the year in which the undisclosed asset located outside India was acquired. So it cuts across both ways. Meaning if you were resident in that year, still you can be subjected to the provisions of black money law, even if you become non-resident at the time when the income or the undisclosed foreign asset is being assessed. Now, this really creates a whole lot of complications, because in many cases we have seen that in case of especially change of residential status, people may miss on reporting the assets and people may not disclose certain assets, and the department may come knocking at your doorsteps to check as to whether they can invoke the provisions of black money law. Now take this case of Vikash Marda, where the assessee had invested in an NRF account from foreign income. Now the assessee thereafter became a resident, and the department wanted to initiate the provisions of black money law. This specially happens because today, under the information exchange mechanism, the income tax department receives the information of all Indians. And in many cases, they will simply look at the present status of the ITR. So if in the present status of ITR, you are a resident, they've received information of you holding foreign assets, they will initiate proceedings against you. Fortunately, ITAT Kolkata in this case came to the rescue of the taxpayer and held that the assets acquired from income taxable outside India cannot be undisclosed foreign assets for the purpose of Black Money Act. This is very clear from the literal reading of the provision, and in that sense, judicially accepted also. Since the penal provisions under Black Money Act are applicable to non-disclosures of ITR, the same cannot be applicable to a person who was non-resident at the time of acquisition of assets and who did not have any obligation to report under Section 139 in those years. However, what must be remembered is the risk of 42-43 after they become the resident. This we have seen getting invoked in so many cases, because when people will come back to India after exercising employment, they will have umpteen number of foreign assets, because while they were exercising employment outside India, they continue to amass foreign assets. Now, because when they come to India, typically they may forget on disclosing these assets in India, they were subjected to this penalty of 10 lakh rupees under the Black Money Act, and this penalty will be applicable for each such default. Tanmay, you want us to take through the interplay between the IT Act and the Black Money Act, and then other statutes as well?
Sure, sir. I'll do that.
Yeah.
So firstly, I think what will be relevant in our discussion is the interplay between BMA and IT Act, because as we discussed, there is a significant amount of overlap between the two laws. So as we were discussing earlier, while seeing the provisions of Section 4 and 5 that deal with the computation and scope of the undisclosed foreign income and assets, it makes it evident that income which has already been assessed under the IT Act cannot be reassessed under the Black Money. And similarly, where the Black Money Act has been used to assess some undisclosed foreign asset or income, the same cannot be used to cannot be assessed under the Income Tax Act. So, what is important to remember is that therefore both the laws are mutually exclusive, and the charge is not being created twice with respect to the same income. Rather, there is a clear distinction being created where the benefit of any previous assessment under either of these laws is being given in the other one. Now, an important recent decision that we came across was that of Ashok Kumar Singh in the ITAT Delhi. So what happened in this case was that a protective addition was firstly made under the provisions of the Income Tax Act under Section 68 by treating certain sums as undisclosed, unexplained cash credits. And subsequently, a substantive addition was made with respect to the same amount under the BMA. Therefore, essentially, the same income was getting taxed twice. So in this case, the ITAT held that once additions have already been made under the BMA, then the provisions of the Income Tax Act can no longer apply with respect to the same income and in the same set of facts. And therefore, it was held that only the assessment under the Black Money Act was valid. A similar situation arose before the Gujarat High Court in the case of PCIT versus Income Tax Settlement Commission. Now, in this case, while the Settlement Commission was in operation, a search was conducted in the case of an assessee, and he went before the Settlement Commission to disclose all the incomes and make the requisite payments of tax. After he had done so, proceedings were initiated under the Black Money Act also with respect to the same assets regarding which he had applied for settlement before the commission. Now, aggrieved by this, he approached they went to the High Court, and the High Court held that since the undisclosed foreign income and the undisclosed foreign asset has already been assessed and charged to tax under the Income Tax Act, be it through the Settlement Commission route, the provisions of Black Money Act can no longer apply. However, an SLP against this judgment is currently pending before the Supreme Court. So therefore, it will be quite interesting to see what direction the Supreme Court takes this in. Another question which is very relevant in this case is both these cases dealt with situations where those particular assets and income had actually been assessed to tax under the Income Tax Act or the Black Money Act. Now, what if in a situation you have undergone, let us say, a reassessment or an assessment, and certain inquiries were made, maybe not as detailed, under the Income Tax Act, and you were given a clean chit and a clean assessment order was passed in your case. However, subsequently, some new information has come to the fore, and the Income Tax Department wants to therefore invoke the provisions of Black Money Act by treating this as undisclosed foreign asset or income. Now, this situation is slightly more of a gray area because the question whether that undisclosed foreign asset or income has already been subject to assessment under the Income Tax Act is slightly more open, because there is no particular order which has been passed with respect to the said assets or income. Therefore, again, this issue is also something which we will see further development in, and basis that the positions under both the laws will have to be seen subsequently. Now, the next question which arises is that, okay, assessment is clearly provided for under the BMA. What about penalty and prosecution? Because again, the events for the penalty and prosecution, the ingredients of those sections are quite similar under both the BMA as well as the IT Act. So now, in this respect, firstly, I think we can refer to this case of KC Builders, wherein the Supreme Court held that once penalty for concealment of income has been deleted, the corresponding prosecution under Section 276C for willful evasion of tax is liable to be quashed. Therefore, what it essentially says is that once the ingredients on merits regarding the penalty have already been set aside, and it has been held that those are not getting satisfied in a particular case, the corresponding prosecution also cannot take place. However, an important thing to note with respect to black money before concluding that this will also be applicable in black money is that there is a section 48 which explicitly states that prosecution proceedings are independent of any other proceedings, be it assessment or penalty, under the BMA. So therefore, even if, let us say, you get a clean chit in the assessment proceedings or penalty proceedings, the department may still look to invoke the prosecution provisions of the BMA in order to, with respect to any undisclosed foreign asset or income. Now, particularly in this recent case of Sanjay Bhandari, the Delhi High Court had held that initiation of prosecution for willful attempt to evade tax is not dependent on the completion of assessment. So therefore, it has lent essentially what the Delhi High Court has held, that this section 48 is correct, and therefore prosecution can happen regardless of what is happening in the other two proceedings. Therefore, what we need to be quite cognizant of the fact is, like as Karan sir was previously mentioning also with respect to section 275 regarding the penalty provisions, that the protections and the jurisprudence which we have been relying upon until now under the provisions of the IT Act, that may not simply be transported and transplanted into the provisions of black money. So that is something that needs to be seen. Now, other issue is regarding the interplay of black money regarding non-disclosure of foreign assets. That is the penalty for non-disclosure of foreign assets. So as we were discussing earlier, the wordings of the section 42 and 43, those are quite clear, and they say that where either the ITR is not filed, or if the ITR is filed and no disclosure is made, in that case, a penalty of 10 lakhs has to be imposed. However, through jurisprudence, certain exceptions have been created to carve out exceptions. This can be seen to be in line with the provisions of section 273B of the Income Tax Act, where in the case of bona fides, relief is granted against the imposition of penalty. So I'll just take everyone through 2-3 case laws regarding these exceptions which have been created. The first is regarding this case of ITIT Chennai in Palani Rajarajan. In this case, the assessee was a RNOR until AY 1314, Subsequently, by AY 1617, he had become a resident. While filing his return of income for AY 1617, the person did not, the assessee did not make any disclosures in his ITR. However, once search proceedings were initiated, he filed a belated return disclosing those assets, and also during the course of the assessment under 153C, he again disclosed it in the return which was filed pursuant to those provisions. However, despite these disclosures being made, the AO levied penalty under 42 and 43 for late filing and non-disclosure of the assets respectively. So the tribunal here gave relief to the assessee on the point that firstly, the penalty under section 43 is discretionary. So it is important to note the penalty under 43 has been deleted, which is with respect to the non-disclosure of the undisclosed asset while the return is filed. Secondly, what the tribunal held was that this was clearly a case of inadvertent mistake on the part of the assessee. The source of the assets had been explained, and they had even been disclosed subsequently in the belated return. So therefore, there were clear bona fides in the case of the assessee, and it was a mistake for which no penalty should have been imposed. So therefore, the ITAT has essentially read down section 43 and given relief to the assessee. A similar case was before the ITAT Mumbai in the case of Timothy John Brinkman, in which a British citizen became resident in India in 2223. He failed to disclose the assets which he was holding outside India in his original ITR, but he later revised the return of income and declared all the assets and paid all the taxes which were due. Despite that, the penalty under 43 was imposed on him. In this case, again, relief was granted to the assessee by saying that once he had disclosed the foreign assets in the revised return within the prescribed time, and there was no evidence of black money or prior Indian citizenship, there was no question of this being an undisclosed foreign asset or income that needed to be disclosed under the ITR, and relief was granted here also. Now, moving on to another aspect which we were touching upon earlier regarding the interplay between the provisions of BMA, FEMA, and PMLA. So, as we were discussing earlier, in 2015, all of these three laws were brought in together. Amendments were made to the PMLA and FEMA, and the BMA was introduced. The overall idea between all of these three provisions was to make sure that not only are the assets which are held outside India taxed in India, but those assets are also brought back to India. So firstly, let us refer to the provisions of FEMA, which were brought into the picture by this 2015 amendment. So what the important section there is, section 37A, which empowers the ED to seize value equivalent in India of any foreign exchange or foreign security or immovable property held outside India in contravention of Section 4. Section 4 of the FEMA says that no person resident in India can acquire, hold, own, possess, or transfer any foreign exchange, foreign security, or any immovable property situated outside India. So, therefore, as can be seen, the contravention is provided in Section 4, and the interim measure to protect against the disposal of such assets and to protect the interests of the Indian government and the Indian taxpayers was Section 37A, which provides for interim seizure. Other than that, amendments were also brought to the penalty provisions under Section 13 of the FEMA. What it says is that in addition to a penalty up to 3 times the amount of the contravention, which can be imposed under Section 13, the assets can also be confiscated. Secondly, the adjudicating authority under FEMA can also ask the person to bring those assets back to India. So therefore, if we see the entire scheme of these provisions with the BMA is providing for a situation where you have acquired assets and they are going to make sure that you pay the adequate taxes on that. Through FEMA, the government is ensuring that those assets are also brought back to India. And if not brought back to India, they are at least regularized by way of, and if not back to India, they are either, the government is not at a loss by confiscating value equivalent in India. So broadly, these are the provisions under FEMA. Now, we have already discussed the aspects of confiscation and penalty. But one more thing which is important to notice here is that even FEMA, which is otherwise a civil law and does not provide for penalties, because FEMA was introduced with the very intent of decriminalizing FERA and making sure that only penal consequences arise in the form of penalties and no prosecution is provided. In 2015, it was also amended to provide that the adjudicating authority can initiate prosecution proceedings where the assets which are held outside India are valued at rupees 1 crore or more. And in that case, imprisonment up to a term of 5 years is provided along with a fine. So clearly the approach of the government is to deter people with a stick, a carrot and stick approach, that you either comply with the provisions, you regularize your investments, you regularize your holdings, or you will be penalized, you will be prosecuted, and from all angles, your escape routes will be closed. Now, particularly with the way the enforcement agencies are now interacting with each other, day to day we come across cases where the income tax department has given some reference to the ED, or the ED has given some reference to the income tax department. There is a very robust information exchange which is happening between departments. It is not just the income tax department and ED, rather all tax departments, including GST, as well as the customs authorities, which are exchanging these informations with each other and making sure that there is no escape for a person who has contravened any of these provisions.
So Tanmay, say for example, if an asset worth 10 crore is found outside India, the amount that could be payable under black money law, that could be say 12 crore, right?
Correct.
So 3 crore worth of taxes, 9 crore worth of penalty. So that's about 12 crores.
Correct.
On top of it, you're saying under FEMA, the penalty could be 30 crores.
30 crores, and the 10 crore worth of those assets in India can also be attached.
seized. So once your assets are seized, on top of it, now we are looking at a monetary outflow of 42 crores potentially.
Exactly.
Hmm.
Now, just the last aspect that we are dealing with is the PMLA. Now, the offense under section 51 of BMA, which is for the willful attempt to evade any tax, penalty or interest, is also a scheduled offense under the PMLA. Being a scheduled offense, any money which is earned directly or indirectly from that offense of willful attempt to evade tax, that will be considered to be proceeds of crime. Being considered proceeds of crime, if any attempt is made to hide that proceeds of crime, it will result in the invocation of section 3, which is the offense of money laundering. Therefore, in case you are holding an undisclosed foreign asset or income, regardless of the fact that outside India you may have paid taxes with respect to that income, or you may have acquired it through legitimate means, even in those cases, the provisions of PMLA can be invoked, and the imprisonment under the punishment under section 4 for imprisonment of 3 to 7 years, along with the fine. And in addition to that, the provisional attachment, seizure, freezing, and confiscation can also happen. So therefore, if we look at it, the government has tried to make this as foolproof as possible to cover all angles and make sure that regardless of what is the activity through which you have acquired those assets, either under FEMA or PMLA or BMA, it gets its dues. So I think with that, we will just conclude our session. And we thank you very much for giving us this opportunity.
We can take some
We can
Q&A.
take a question.
Yeah, please go on the queries of the members.
Yes. So I think first question we are seeing is whether old tax dues are covered under BMA. I understand, I think Vijay Kumar sir has posed this question. I understand the background is as to whether there are some old assets and incomes, whether those can be subject to Black Money Act. If that is a question, the answer to that is yes. So even if the assets and the incomes were generated prior to BMA, at least charge of tax wise, there can be a valid charge of tax on them. On penalties and prosecution, I think we've discussed, it's a litigative issue and the matters are still being litigated. Yeah, next is, I think Sanjeev sir has asked whether BMA applicable in case of resident in India holding assets outside India, which were acquired being NRI. So I understand, I think this we've again covered in detail. So the point is, if the assets were acquired at a time when the person was non-resident for the purpose of IT Act, then the black money law does not apply to those particular assets and incomes. But what must be remembered is that in your ITR that you are furnishing, if you don't disclose these assets, then under 43, there could be a penalty of 10 lakh rupees for each such failure for each of the financial years. So if for 5 years you don't disclose after becoming residents, you're looking at a penalty of 50 lakh, 10 lakh for each of these years.
If
Whether-
you disclosed in all the years and omitted to be disclosed in any one of the years, even then the penalty will be payable. He has a known source. He is disclosing in his returns, but in one of the years it was omitted to be disclosed inadvertently. Even then the penalty of rupees 10 lakh will be imposed.
Yes, so I think Subhash sir has also asked this question. To my understanding, literally read, the answer to that is yes. Under section 43, the penalty is for default for each year. So for the year in which you have not disclosed, there is a default. I think we covered one case law. This is subject to assessee proving the bona fides. Now, what I understand is if you've been disclosing year after year, but there is omission in one of the years, obviously levy of penalties are subject to bona fides. So literally read, the penalty could be there, but you can say there is a reasonable cause, etc. And on that basis, you may try and defend the penalty that is sought to be levied against you. Next is FTC for taxes paid outside India will be adjusted by AO against tax demand under undisclosed foreign income and assets. Sanjeev sir, according to me, the answer is no. Black Money Act is a separate statute. Though it is a tax on income, it does not provide for credit of any such taxes. Therefore, if you have paid any foreign taxes, say on a foreign income, which remains undisclosed in India, no credits are available against these particular taxes that are paid outside India. In fact, for that matter, black money does not even have something equivalent of section 90 and does not have any treaty protection also. So in that sense, even if there are some treaty benefits, etc., that are applicable, even those cannot be conferred when it comes to black money law. So FTC in any case is a creation of treaty. The treaty provisions itself don't extend to Black Money Act. Next is if a default of non-disclosure. Okay, I think this we've already addressed. Subhash sir asked that if there is a default in one of the years, I think we've already addressed that. Sometimes UFA is very less, maybe less than 1 lakh. In that case, penalty of 10 lakh is leviable. Again, I think Mohit sir, the answer to that literally again is yes, because this is an objective penalty. It is not up to a particular amount. And in that sense, also the penalty of 10 lakh could be there. Again, subject to bona fides and all that we've already said. It means once default is committed, it will be of great risk to disclose in any further year. Okay. Sir, Subhash sir, I think yes. So what you're saying is if default is committed in 1 year, it will become difficult to disclose it in the future. Like if you disclose it in the future years, then definitely you are looking at penalty in 1 of the years. Sir, my suggestion is to have a different approach to that. Maybe a slightly different approach. Now the thing is, where you have already made default, say in year 1, if you continue to make default year after year after year, you're actually piling on the penalties. And in fact, you'll be running the risk of someone even questioning that is an undisclosed foreign asset, etc., getting into a whole lot of complications. I would advise, can we do one thing? We go and disclose in year 2 and file separate side letters to my AO. I file a simple letter to my AO saying that there has been an omission. I can't revise my ITR now. And therefore, I am disclosing that I already hold these foreign assets. As I said, penalty is subject to a reasonable cause, etc. Therefore, if I go and prove to my AO that I had already made these disclosures, though not through ITR, but through separate side letters, we'll have a very good case to say that penalties, etc., should not be levied in this particular case.
Application under section 192B can also be made asking for the revision of belated returns belatedly because of this omission.
119 to CBDT, you're saying 119.
Yeah.
See, again, those applications can be made, yes, but obviously we know from practical experience, we all know that CBDT generally does not condone that delay. And for specially like our purpose is to get an immunity from penalty. I think a side letter will also do wonders for that purpose, because we're talking about a penalty having already disclosed, though not in ITR. I'm sure we'll have a good case, but obviously having after filing the side letter, if I want to be extra cautious, I can file a application under 119 to CBDT or commissioner, etc., as the case may be, to try and get a condonation of filing a revised ITR as well.
One
Uh,
more
in-
practical solution to this problem I have used and I wish to share with the fellow members कि अगर पिछले सालों में मैंने डिक्लेयर नहीं किया था तो आईटी लॉगिन में रेक्टिफिकेशन जो टैब है वहां पे XML दोबारा अपलोड हो जाता है विद द रिक्वेस्ट ऑफ रीप्रोसेसिंग इवन आफ्टर 3-4 years इट इज अपलोडिंग FA को हम दोबारा फिल करके अगर XML दोबारा चढ़ा देते हैं और रीप्रोसेस की रिक्वेस्ट डाल देते हैं तो वो इसको कर रहा है सर मैंने 1-2 केसेस में ट्राई किया है तो आई थिंक सो दैट मे आल्सो हेल्प इन द प्रोसीडिंग्स व्हेन द पेनल्टी कम्स
Correct.
बिफोर
Correct. Absolutely right, sir. Absolutely right. Because the idea is to inform the income tax department, and this may work out even as a better solution, because then you may have it in your ITR also.
Yes.
Information received on 20th March 2024 regarding an old foreign asset, for example, for year 2002. Notice under section 10 is issued on 15th April 2024, of which year is taxable. So the year in which notice is issued, it is taxable in relation to that particular year. In this case, notice is issued in April 24. Therefore, assessment year 25-26 should apply.
Means
Last-
the AO will issue me the notice for the AY 25-26 in that financial year itself, sir.
Yes, sir. Because the law says that you have to see the charge is created in this particular statute in which it comes to the notice of the officer. Now, the notice is like, in that sense, the assessing officer communicates his knowledge through the notice. So in that
no, sir.
particular,
यहाँ पे सर मेरा एक्सक्यूज मी मेरा जो काइंडली कंफ्यूजन है ना वो 72C का है सर 72C speaks that where any asset has been acquired or made prior to the commencement of this act and no declaration in respect of such asset is made under this chapter, such asset shall be deemed to have been acquired or made in the year in which the notice under section 10 is issued by the assessing officer, and the provisions of this act shall apply accordingly. Now, in my given case, the property will be deemed to be acquired by me in the financial year 24-25, sir. Right,
correct.
sir? So,
Correct.
first question is my ki whether in the financial year itself a notice can be issued for that very financial year, for that very assessment year, which pertains to that financial year.
Sir, I'm not clear on the query. You're saying now that the notice is being issued in April 24, you're saying whether it can be deemed that the asset is acquired in 24-25. Is that the question, sir?
Yes.
The answer to that is yes, sir, by virtue of 72C.
72C, but the tax will be levied in the on its value which was in the financial year 23-24 as per the rules
Yes, sir.
by virtue of section 3, right, sir?
Correct. So the assessment year becomes 25-26. For valuation purposes, we go back to the year time of detection.
Ji.
Okay. Last is what will happen if for any particular year a person has disclosed his foreign income like dividends, but did not disclose in Schedule FA like his foreign share account. Will it attract any penalty? Also, this could be proved as a clerical error. I think Kamaljot sir, we've already discussed this in detail. Deepak sir also provided a practical solution to this. That if you've already, I think we've already stated that these may not constitute your undisclosed foreign assets, foreign incomes for the purpose of charge of BMA. Penalties, etc. under 43 could be there. But we have said that there are practical solutions to avoiding that penalty. If a person has an asset as share capital in the company and the company is not earning anything, what to disclose and where? So even if the company is not earning is not the, I think, test here. If the company is incorporated outside India, it still constitutes an undisclosed foreign asset. So while disclosing the value of the undisclosed foreign asset in Schedule FA, you may take into account the fact that the company in that sense doesn't have any worth, but the shares nevertheless are to be reported. Minded, the authority, the tax authorities of the country where the company is incorporated, they'll be sharing data with India. If you don't disclose, the department gets to know it. We may be looking at a penalty under section 43. So to avoid that, it is better to disclose it today itself. Sir, I think we've addressed all the questions.
हाँ जी, जे जैन जी काइंडली देखिए, आगे चलाना है, कंक्लूड करें सर।
दीपक जी, जैन साहब अभी है नहीं, तो
राइट सर,
मैं टेकअप
मुश्किल
भी
जी
कर
आप
रहा हूँ.
बताइए।
If any member is having any query, he can raise his hand. I think in chat box all queries has been resolved.
तो शुड आई प्रोसीड फॉर द क्लोजर, सोनी जी?
I think nobody has raised his hand as of now. I think all queries are resolved.
Thank you, Karanjot ji and Tanmay ji, for your wonderful session and deliberation in detail and minutely. And now I request my Vice President, Sir, Sanjeev Bhandari ji, to have a concluding remarks and a vote of thanks for the today's webinar. Sanjeev Bhandari ji, please.
Thank you, Deepak ji. Respected President, sir, senior members, I acknowledge also presence of Sri Rajneesh Goyal ji, Rajiv ji, Kushal ji, Subhash Jain ji, H.K. Nijja ji, H.O. Roda ji. In sum up, I would conclude that BM is applicable for only UFI8 transactions. Those are mainly illegal from activities or illegal structures, or if legal, those are not disclosed to the income tax authorities by way of ITR and taxes are not paid. So very good deliberated by both the dynamic speakers, CA Karan Joshi, Khurana ji, Advocate Tanmay Bhatnagar ji, for their depth knowledge and insightful discussions on this topic. I would extend my gratitude to both the dynamic speakers. I also extend my sincere thanks to our study circle convener, CA Rajesh Jain ji, Pushkar Soni ji, and their team, as well as executive body for scheduling this webinar in a short span of time and choosing a very important topic, BMA. I also extend my heartiest thanks to our esteemed members for their gracious presence and active participation in making the webinar very interactive and alive. Lastly, I am thankful to all of them, all the teams, for making this webinar a huge successful. Once again, thanks to all of you. Have a wonderful day. Thank you.
Thank you, Bhandari ji. Thanks all. Thanks to the speaker and all the participants. Now we may close the session. Thank you, sir.
Thank you,
Thank you.
everyone.
Thank you, everyone.